All right. I believe you can hear me right now.
Yes, sir.
All
Yes.
right. So let's just move on. When we started this section of the course as it relates to mean, we began by looking at the main topic, which is African jurisprudence. And in the course of that particular class, we made our time to understand what we mean by African jurisprudence, and which is an attempt to straighten the records which has been either to misconstrued or which has been presented wrongly. And we have a duty to explain as to what African jurisprudence is all about. And in the course of that discussion, we looked at the various misconceptions that have been put forward against the concept of African jurisprudence. And we look at various scholars, particularly we look at W.F. Hegel. We consider the view of Sir Henry Maine, also Louis Morgan, and the rest of them. And whatever view they had, we were able to establish that it just amounts to their own view without representing what African jurisprudence is particularly all about. And all of these were more like the prejudices that the Western world have established against the African nation. And aside those scholars that we mentioned, we also established about 6 or 7 of what we call mystical misrepresentation of the African history, and the various arguments that they made, which indeed happens to be the focal point of their argument. We looked at them, and then we concluded the class. You know, among all of those misrepresentations that we looked at, I remember we talked about that Africans do not have a history or a past. That happens to be one of their major position. And in the course of the discussion, we did establish that even before the advent of the colonial masters, we had a system of law that was in operation in our area, and they served the best interest of the community as at that time. And at the fact that they do not, the system that was operational in Africa then, the fact that they do not look like the one obtainable in the West does not make it less of a system. And of course, we showed how the great the various civilizations that we have had even before their arrival. I remember we talked about the Mali Empire. We talked about the Kingdom of Kush, the Great Zimbabwe, and the ancient Egypt. All of that were great civilizations that were already in place even before the advent of the colonial masters. And then the second point we looked at was that they said Africans have little or no system of law before the arrival of the colonial masters. That also we were able to debunk by the avalanche of positions or history that we have to show that indeed our system were up and running. Of course, they also allege that African jurisprudence have no respect for individual rights. And again, we did establish under that concept that even though the African jurisprudence is community-based. That is based on communism. That in itself shows the interest of the community in the life of individual, because individuals actually makes up the community. And we did establish that the position as held by the Westerners is not correct as to the fact that Africans do not have respect for human rights. Also, we looked at the other point that African jurisprudence is positive and not negative. We did establish that, yes, it may appear so that we do not focus on punishment, but of course, the law of, African laws specify what must be done and what should not be done. And the emphasis is not on punishment, but to ensure that we have a community that is up and running. And the fifth one we looked at is the fact that they said there is no such thing as the unity of African law. Yes, we agree that the African nation is, a combination of many ethnic or many nations with their different unique legal system. But of course, even though we cannot say we have a single law that amount that we can call African law, yet we have, our own system that work for us. Of course, they need not be together, and then it's sufficient to take care of the need of the people. And the seventh one we looked at was the fact that he talked about the unrestrained usage of powers in the African setting. And of course, as we also see further in the course of the lecture this morning, we see that that position is actually not true, and is against what the African nation, stands for. So this morning we will take the lecture forward by looking at African concept of law and jurisprudence. That will be the topic that we will look at today after this particular review that we've just done. So, in the course of the class today, we will also see, more about all that we need to know on African jurisprudence. So, in a short while, we will move on. Just give me a second. Okay, so like I said, the topic that we are going to take to take this particular discussion further is African concept of law and jurisprudence. Now, in the course of our last class, we discussed and we did establish that African jurisprudence is the branch of legal philosophy that seeks to understand, analyze, and theorize about the nature, the sources, principles, and purposes of law in African society, and both traditional and modern. And all of that gives us like an overview of what African jurisprudence itself is all about. As a matter of fact, is that is particularly unique to the African nation. So when we talk about the African concept of law, is to give us a view of what the law Hello? Hello, can you hear me?
Very yes,
We can
sir.
hear you now, sir.
Very now.
All right, thank you. So, by way of introduction, we need to know that among the various views expressed about African law, one of the major things that is central is that law is a possession and privilege of a restricted people, meaning that law is only applied to and only protects specific group which recognizes it. And no wonder it appears that even the Western world and those who have, preached the wrong message about African law fail to recognize this particular position about law. So, law is a part of the whole complex of culture, and therefore, only those who claim the same cultural inheritance come within the scope of its operation. So, therefore, the African concept of law is unique to the African nation. And again, because the system is made up of units, I mean, the community, the various ethnic groups forming a nation, forming the continent, or forming the area that they generally be referred to as the African nation, is made up of different units. And that's why we said that even though there's a claim that we do not have a unified law, that is because of the fact that the component units that makes up the entire African that they refer to is not just one. And then, of course, like I said, it's made up of units, made up of even family. And at the same time, we have what we can call clan or tribe. And all of these, they have their own customary law, which is directed towards maintaining the interest of that particular unit against people that we can call outsiders or those who do not subscribe to the type of law that is operated in that particular community. So this position that law is the possession and privilege of restricted people has gotten judicial blessings in these various cases that we have listed before you this morning. We know the popular case of Zidane and Mozen, Nwagwe and Okeke, Owoniyi versus Omotosho, and so on and so forth. All of these have described customary law as a mirror of accepted usage. That is a set of rules of conduct applying to persons and things in a particular locality. And that speaks of the fact that, yes, the concept of law, African concept of law is indeed unique. So also are other nations or continents or even areas where they claim to even to be superior. But what is central to this introductory part is that these laws are applicable to those who are subject to it, that is, those who have identified with the particular community. And then it does not in any way apply to outsiders. And of course, the outsiders that we mentioned, in this introductory part relate to those that we can call foreigners. And when they find themselves in a particular location where there's a particular custom, a particular customary law that they are not used to, they can claim no protection under the law except where the system of law provide a temporary protection for them. And of course, that usually come under the law of hospitality, which in case they are granted the same status as their host and can plead, in the name of their host, meaning that if they find themselves in a particular clan, in a particular unit, in a particular tribe, foreigners, that is, those that are not covered by that law, can also, in a way, just enjoy a part of the system of law that is, available in that place. And of course, this situation sometimes can be related to the concept of international law. And again, that brings to mind the fact that the African system, African jurisprudence itself is unique and has its own element of, law that relates to the international system. And like we said, even in this, in the local setting where particular cultural law are enforced, they protect foreigners. And even in other areas of life, like when there is war, when there is a need to marry indigenes, when there is need to engage in economic relations, and all of that, these particular foreigners that are not directly subject to the local laws, have a way to fit in into the system. So African legal structure has its uniqueness and its own specific structure and peculiarities. And that's why we've established earlier on that law is the possession and privilege of a restricted people. It is embedded in the culture. It's not universal. And that's why it's not, you can't find a universal law that particularly address or takes care of every concern. And we've noted there that it's applicable to those sharing the same cultural inheritance. And this will include family, clan, and all of that. And by way of further explanation, that the foreigners that find themselves in these areas, enjoy temporary protection by the law of hospitality, and then they can integrate into the system by, having intertribal marriage, or even applying the law of war, economic relations, and so on and so forth. So the unique structure of African law in itself is distinct to every other law. And that's why when Ll.B. made his own submission that it's even wrong for anyone to make an attempt to compare the African jurisprudence with other system of law, because they are not the same, as these two systems of law, cater for different purposes. And in catering for these purposes, they also work to achieve what is best for the community. So when we look at the unique structure of African law, we will see that to the African, law comprises of all those rules and conduct which regulate the behaviors of individuals and communities, which by maintaining the equilibrium of society are necessary for its continuance as a corporate whole. So in defining law, our definition, we will find that African law is positive, not negative, just like we've rightly said in our previous engagement. It does not say thou shalt not, but thou shalt. That is to ensure that what the rules of the societies are is adhered to and is practiced in a way that will bring complete benefit to the society. And in all, its object is to maintain a balance within the system to ensure that, oh, every part of the community benefit from what is available within the system. And then it, does not really seek to make criminals to suffer, but to correct the wrong and to ensure that the society continue to run and to benefit, together as a whole. And at all times, the African system of law ensures harmonious living within the society, even though there is no written code, but the law itself is organic, it's unique, and again, it aids the the societal life of the particular society where this is to be applied. And again, we'll say that apart from the fact that it is organic, is coherent and also traditional. Traditional in that it applies strictly and mainly to all those who are subject to its way. And it is always constructive and palliative. That's why those who attack African system to be that it does not cater for this and that, they fail to look at the fact that the purpose of law for the African society is to see how life can continue, how life can be managed by the various organs that exist in the society. Even though when a crime is committed, is seen as a crime against everybody. And the focus of the community in African society is to ensure that every party is taken care of. And then there is this maintenance of social equilibrium, which means that no party suffer and everybody also enjoy whatever right that is to be given to them. And of course, that does not mean that the African system of law does not punish infractions. As we will see in the course of the class, that yet there may be focus on trying to prevent or to make people to do what they're supposed to do. But again, the African system has its own way of regulating itself. So which does not only border on this is what you must do. The law, the African law or African system of law also cater for situations where if an individual goes contrary or does not do what he's supposed to do, the law has a way to take care of such infraction without jeopardizing the harmonious living that is expected in the society. And that's why we have features and sanctions in African law. So generally, like I said, African law is not vindictive. And the idea is to make the punishment fit the crime. And that is why under native law, a thief so often goes unpunished. Because if theft is committed, the material equilibrium has been impaired. But if restitution is made, there is no more to be done. Or if someone has done something wrong and is able to restitute, then we will feel that, oh, everything is okay. And again, when you look at it, even though the concept of punishment in a way can bring about deterrence, but what immediate benefit will a victim get when the law is to take its course? And that's why one of the major features of African law is the restorative justice. Of course, if the victim has been put into the pre-victimization stage, it's preferred that, oh, the person who is supposed to suffer is not suffering. And then what else can be done to make the society better from the action? The person who has committed an infraction may be summarily dealt with, in some ways, in order to also serve as a form of deterrent to others who may want to engage in it. So we'll talk about other sanctions that are prevalent in the African society. Now, talking about sanctions, these are structures that have been put in place in maintaining social equilibrium. For example, in West Africa, we have secret societies. They tend to operate as a sanction for the observance of the law. Many of them, like the Oro and the Ekemekus, are police societies which act as a guardian of public morale and also punish offenders. They make, thieves to make restitutions and engage the usage of the gods to even reveal offenders. And basically, that's one of the major things that even the modern day system lacks. Somebody may have committed a crime and is telling a lie and is insisting on his lies. And there is nothing in any way to reveal whether he's the one that has committed the crime or not. But in the African system, then, all of those could be revealed by the engagement of the gods. So, looking at the sanctions that we have in African law, we have the religious sanctions. And of course, this is in talking about religious sanctions. In every society, like I've said, the various religions also form part of the system of law that guides the society. So primarily the law is obeyed just because it is accepted, because it forms part of the religion or the beliefs of the people. And again, its acceptance and its position as an integral part of the social organization are its own sanction. So if an individual obeys the law based on his religious belief, it has one way or the other, brings benefit to the society. And if not, the religious laws also provide for various sanctions that can be applied to individuals who are found wanting. Some of them, they can be banned from participating in some religious activities or even made to face some form of also religious sanctions that we may not, categorically mention in this discussion. Another type of sanction prevalent in African society is what we call the magical sanctions. Okay? What we call the magical sanctions. All of these are what can be referred to as automatic penalty in case of certain offenses. And that's when we talk about law of karma, when somebody does something and immediately there is like the gods, moving into action to punish, the individual. And sometimes, of course, the gods play a prominent role in this aspect, in that there can be curses laid on those who are found to be disturbing the peace of the society. And again, even all other systems of a traditional system that operate also can bring about some form of sanction which can be proclaimed on individual. And one of the things that we can attest to is the fact that even human being tends to believe or tend to be afraid of powers that they do not even see compared to the physical power of the states. And that's why somebody can be in court even though he has committed so great a crime against the society, he's still claiming not to have done anything against the society. But take such an individual to maybe like a shrine where which the society believes in can help to reveal secret. Sometimes they don't even get to this point before they confess whatever infraction that they have committed. And all of this makes the African system of law to be very effective, even though that position has been used against the African system by saying that people only obey African laws because of the fear of the spiritual. Whichever angle they look at it, the question that should be asked is that, is the society better off as at that time, especially by virtue of what is available to them to manage the society? Once that question can be answered satisfactorily, then whatever the West or the Western world has to say about this negative perception will not in any way matter. Another one is collective responsibility. In some cases, the community is seen or see itself as one, and accordingly, everyone helps to reinforce group responsibility. Group responsibility in that when an individual is doing something that is against the general good of the society, the various groups in the society will help, to ensure that individuals do what they're supposed to do, because the society sees it as it is everybody's business to see that the laws are obeyed. And if an offense has been committed, the group is equally liable to spiritual retribution. And they see that as a form of punishment. And that's why in the traditional African society, it's against the law of the society when two people are fighting and then a standby will just stand aloof and encourage the quarrel or the fight to continue. The society, the gods of the land, have a way of punishing such individuals. But what do we see today, even in this time where we feel that we are modernized? If two people are fighting, the next thing is that people go on social media, even broadcast the event live, while failing to make attempt to stop whatever it is that these two individuals are doing. But that is what we call, modern life situation that, we either prefer even more than what was obtainable in the indigenous African society. So there is this collective responsibility, and the collective responsibility brings about spiritual retribution and sanctions to those who go against the welfare of the community, because the community is seen as one. Another sanction that we can see here is ridicule and ostracism. Now, ridicule and ostracism as a legal sanction is an idea that is now, foreign to us. We no longer, use it in our current system, probably because of the various laws that tend to protect various rights against abuse. But of course, we can see some sense in not deploying ridicule because of the fact that actually when an individual is apprehended or is alleged to have committed an offense, there is need for such crime to be established. And that's why the presumption of innocence is a very central key in criminal prosecution. But of course, even though we do not directly have this kind of sanction in our system today, but it is still prevalent. That's when we talk about social media trial. I remember at the time when a popular artist, was alleged to have committed a rape. The kind of publication that went on in the media is similar to what we are talking about that was obtainable in the African society. Oh, okay, we may say that there is nothing like ostracism again, but at the same time, even when you keep a man in prison, you've taken the man out of circulation. It's like sending him out of the entire community. But what we are saying in essence is that all of these points that we have listed makes the African system of law to be unique and different from every other system of law that may exist in other society. And the question again that we'll ask is that all of these features and sanctions in African law, were they able to meet the needs of the society as at that time? Okay, I said earlier, if the answer is in the affirmative, then there is really nothing to crucify our system for. Meaning that as at that time, everything and everywhere, everything in the society was according to the dictates of law that was in operation as at that time. So the conclusion on that is that the African system of law is unique with its own special component, and that should be respected in all ways. So in taking the discussion forward, we look at what we have in our contemporary time and what was obtainable and what the African nation practiced as at that time as part of trying to establish or to have good understanding about the African system of law. And that's why we'll tag this jurisprudential throwbacks to traditional concept of law and justice in Africa. Now, again, the traditional concept of law in Africa is variously defined by customary law, religious law, common law, Western civil law, and other legal traditions, and the combination of all of this. Why do we have to talk about this combination? The truth of the matter is that as at that point in time, even though we had our customary law, the religious law also came into play. When we were colonized, part of the law of the West also came into our system. And that's why today, even as a nation, we still know that we are still a pluralistic society where the customary law and the other laws that were foisted on us also still take priority. But what we need to establish is that prior to colonization, the indigenous laws of African continent were implemented based on the custom and practice of tribal populations. And that was what was unique and was meeting the needs of the society as at that time. But even despite the legislative advancement of respective communities, all indigenous laws were uncodified and exclusively managed through oral practice. Yet, as the communities began to grow, began to have some form of development, those laws that we had were also still very much in operation within our society. And of course, we say that some of the oldest legal systems began first in Africa. If you recall in our last conversation, we said the various systems of dispute resolution that were practiced, that were considered local, that were considered barbaric, that they were considered not popular, is what is prevalent in the modern day jurisprudence. Now, people can boast that I'm a mediator, I'm an arbitrator, I'm a conciliator. All of that are product of the whole African system of law or the practices that were prevalent in African society. So basically, African customary law is derived from the traditional custom and the practices of the various communities. And even though we are many, even though the tribes are many, the truth remains that these custom or tribal laws help to meet the needs of the ethnic groups where those laws find themselves. And again, we'll submit that the traditional African society is divided into two: the kingship and the chiefly society. This is where the king represents the law and oftentimes laws unto themselves. So, but there is need for us to justify their position through jurisprudence. That's why we take step further to look at these pre-colonial legal structures and how they relate to what we have in our present day system. First, we look at the first category, that is that of the kingship society, where the leader, either the king, the Oba, dominates the society with appropriate rules and directives emanating from the gods or the supernatural being, those that cannot be seen, but if seen, they are seen to be the founding father of the society, and they control the affairs of the society. Again, like I said, we have the acephalous society, which is the same as what is popularly known as the chiefly society. And the major distinctive factor in the pre-colonial political organization between the Igbo people of Nigeria and their other ethnic neighbors were the republican nature of their administration, which is known as the acephalous system. If you delve, deep into this, you see that the political administration of the Igbo people before the coming of the Europeans was a collective responsibility of all heads of the individual family units, who passed on their decision to the youth for implementation. Again, that takes us to the fact that the indigenous African system were able to make their laws and also able to enforce it through the various systems that were in place. So, if the elders in council in the acephalous system make their decision and pass it to the youth for implementation, this make the traditional Igbo political society to be republican in nature, with no institutionalized kingship system, because every family, every tribe plays important role in the administration of the society. Of course, we say that the only exception, however, were the trading cities along the river Niger. We talk about the community like Onitsha, Oguta, Arochukwu, and all of that. These communities operated a kingship system long before the coming of the European colonial administration. But all of that still speaks of the diverse customs and society that existed at that time. So the Igbo system indeed, shows that republican society. And it was this what we call village republicanism, that is the democratic nature of the Igbo society, that made the individual in the society to have a voice. It made them to have a voice through their family representation, through the collective decision of elders, that are in the community, and so on and so forth. And that's why it's very popular among the Igbos that the Igbos have no king because of the Republican system of government that was practiced as at that time. And when you consider that political system with that of the Hausa Fulani and the Yoruba, for example, you will see that they are not the same. The Yoruba Hausa system were more centralized, while the Igbo system is more of a Republican and a collective system. In this form, the elders, take decisions and then jointly implemented. Whereas under the Hausa Fulani and the Yoruba system, everything is operated centrally. And of course, that gives the emir or the obas, the powers to make executive decisions, powers to make even judicial decisions, and also they also make law for the society. If you we move on to look at the kinship society, the obas, they enjoy so much unquestionable powers. These are, yes, even though it may look like, oh, what the feature of this system indeed is some form aligned with the position held by the West. But again, we can't take away the uniqueness of every system. In the Yoruba system, the Obas were referred to as the unquestionable being. And that's one of the reasons why you hear the word Kabiosi, meaning that nobody can ask you. But even in today's world, we greet the king Kabiesi. It's an offshoot of the Kabiosi kind of system, meaning that the Oba is superior and is whatever it does is right. But again, in the chiefly or the decentralized society, this was not so because the Igbos have no king. So the entire system, both the ones not having semi-absolute power and those not having the centralized system, they have developed checks and balances. Even though we say the Yoruba system is centralized, the Oba is unquestionable, the point still remains that this system still have their various checks or the ways in which they check their leaders. For example, the Council of Elders represent the ethnics or the morality of the society, and they provide ways to check every individual, even at some point, even the leaders that are in the society. And that's why when if an Oba should do something that is contrary to his power, you know that by the system of presenting the calabash, the Obas can be checked. So simply put, it can even be difficult to conclude that the Obas were unquestionable. They could be questioned, and the system already, put in place how they can, be checked. So, generally speaking, the pre-colonial legal structure of the indigenous African society is, generally divided into two, which is the kinship and the acephalous society. While we place the Yoruba, the Hausa under the kinship or the centralized system, the Igbo practice more of the republican system and they come under the acephalous system. And no, so that is the legal structure. Now, the other thing we now need to look at under this topic is what was the concept of justice in Africa? What is it that is perceived to be justice? That we will see under this conversation. So, in a traditional African society, the judicial system is reconciliatory. Purely reconciliatory. We said that over and over, that The focus is harmonious living. The focus is the continuous growth of the society. That is why restoration of peace and straight harmonious relationship characterize conflict resolution method in traditional African society. How can the people in dispute come to an amicable settlement in order for the society to move on in unison? And that was the major focus of justice, or what was concept of justice in Africa. And then they make the society one, continue to pull the society together. And in the process of this, they embrace some compromises and cooperation in order for there to be genuine reconciliation and for the society to move on. And what is the purpose of this reconciliation method? Is basically aimed to promote mutual understanding and what we call the elevation of social engineering. So even though the element of adjudication system existed, that is a process of reaching and concluding decision in issues of conflict, it was systematic and it was tailored towards ensuring that there is peace. Okay? And the focus is not really to punish the offender, but to ensure that the society, whichever way, is better for it. Even though if the purpose is to identify the guilt or the innocent, yet all is still focused on reconciliation. And then they work towards the aim of preventing a reoccurrence of such crime in the society. So, therefore, the concept of justice in Africa was majorly reconciliatory. It was not, it's not focused on retribution. In the system, you find mild punishment, but in all, peace is what is central to the African society, and that's why the African concept of justice has influenced the global ADR system that we have today. Because what is the central point of negotiation? What is the central point of conciliation as a system of dispute resolution? What is the central point of arbitration, and so on and so forth? And then we begin to wonder, those who spoke against the African concept of justice or African law were indeed not sincere to what they were saying. And of course, probably they knew that they were actually presenting a misrepresentation of, the actual view or the happening in the society. And that's why Professor Akinwebode rightly maintained that all that they did to our system was to copy our system and modernize it. And of course, they failed to acknowledge that the current system of dispute management that is prevalent the world over is a product of African knowledge. It's a product of African jurisprudence. But of course, they have failed to acknowledge that, and then they continue to create stories that are not true, about the African society. But some of the things we need to note is that why we hold this position that the African system itself is unique. It's important for us to know that the system may not on all fours be ideal or meet, the expectation of maybe modern system. But of course, the truth remains that every system develops. And then, even as at now, we have identified various systems that were prevalent in the African system that require change or modernization in order to meet with the current reality of things in the modern day situation. And that's why I'll briefly talk about caution about study and understanding of African jurisprudence. Because everything cannot be taken to be, oh, everything is fine. The African jurisprudence may have its lapses yet, like we have established, but the point still remains that the African system or system of law were able to take care of the needs and aspiration of the people. So briefly, I will talk about caution about study and understanding of African jurisprudence. Now, it is worthy of note that generalization about traditional Africa are always dangerous because of the distances of time and space that are involved. Why do we say so? When Africa as a nation began to evolve, most of the practices may not accord with what we believe to be what is expected of a modern society or a society that respects, every uh, trappings or things that should form to make an ideal society. So we cannot deny that there are many threads of continuity that one can speak about and write about and about African society. And the truth of the matter is that we can only draw a conclusion that the various African laws, African custom, African tradition were not in all round good, but we can draw like a, a system that is able to take care of the society. And that's why there is no single concept of social justice which can be called universally African, because there are so many experiences which the various African societies do have, and they have had in time past about how law is practiced within their society and how they have been able to achieve, what they needed to achieve as a society. So the various experiences as at that time varied from different community to community. More so that the traditional system would not have codes that can say, okay, this is our common code. And meaning, therefore, that the society, one way or the other, were ruled by available custom from different community to community. And then some of the decisions mainly were to enhance social control and to ensure that the society was moving in a way that, that they could, to the extent to which they could achieve as at that time. But what we can say is that the system of justice about African jurisprudence as at that time was not focused on punishing offenders. It was not retributive based. But again, coming back to what we discussed about the concept of justice in Africa is majorly reconciliatory, and to see how people who come against the law of the society, one way or the other, are corrected, made to pay for their offenses in the most simplest way, and again, look for a way to have them reintroduced into the society. So, in all, it may be short that the African system of laws at that time did not provide for a robust system to take care of adequate punishment or maybe focus more on retribution than the reconciliatory. But the truth remains that what was the focus at that time, was how the society can be together. And of course, things have changed up to date, and things are still changing, and the laws, various laws, will continue to evolve. As a nation, where we used to be at our pre-colonial stage is not where we are today because of the development that is taking place all around the world. This also affects every other nation within the African society. So even though we make claims that all is well, or that we believe in our system, we had our own shortcomings. So that's the purpose of trying to create that caution within our system. Now, we also still need to look at some concepts in the traditional African society and how, as at that time, the African jurisprudence were able to use them to also meet the need of the society as at that time. So that takes us to jurisprudential throwbacks on concepts such as constitutionalism, due process, separation of powers, and checks and balances. Even though in our previous conversation we have made mention of all of this, but just for the purpose of speaking to them one after the other is the reason why we are taking this particular subtopic under this discussion. Now, constitutionality in traditional African society focuses on the traditional African governance. The constitutionalism we're talking about today is not new to the indigenous African society. It specifically examines those traditional forms of governance that made the societies to stand firmly before the advent of the Europeans. Many of these traditions were not written down. There were no constitutions to talk about constitutionalism, but they practiced what is now referred to as constitutionalism as at that time. Now, constitutionalism is defined as a commitment to limitation on political powers. Then it is possible to have such a commitment without a single documentary constitution, most especially when commitment is in the blood and culture of the people. And at the same time, those people have a keen sense of their own identity. What we are saying in essence is that, yes, we may not have books to speak to the concept of constitutionalism then, but even the word constitutionalism is also derived from those practices that they saw that were obtainable as at that time, which of course help to check the society, both the leaders and even the citizens Hello, class. Hello.
Yeah,
Hello,
we can
sir.
hear
Yes, sir, we can hear you.
Yeah, so sorry. I think I had some network issues, so I was taking off. Can you
Okay,
still
sir.
see the slides?
Let me just check that.
you, sir.
Yeah, I can see your picture, sir.
Okay, so this slide is it up now?
Mm.
Yeah, it's
Oh,
back.
yes, it's up, sir.
Yes, sir.
Okay, all right. Just a minute. Hello, class. Can you hear me now, please?
Yes, sir, we can hear you, sir.
Okay, all right. Thank you very much. So I was talking about constitutionalism and that even what we have today now and the name given to it in forms of how political powers are checked or how both the leaders and the society, comply with available laws and all of that were, product of what they've seen in time past. Therefore, constitutionalism was also practiced in the traditional African society. And like I said earlier, constitutionalism is a form of political thought and action that seeks to prevent tyranny and generate the liberty and right of individual on which free society depends. And um, and that's why when we talk about a modern society today, and we see either leaders doing what is not okay, we challenge them. And we even when also citizens who are support with the women we use the word ordinary are doing what is not also expected, we also speak against what they do. That's because the concept of constitutionalism covers both the leaders and the leaders who are supposed, to obey the rules of the society. In a modern society, you expect the rule of law to be a guiding factor. In the traditional African society, it was so where if an individual, a leader, fails to do what he's supposed to do, the system has a way of addressing those concerns. In a modern society like today, it's not very correct that everybody is subject to the rule of law. There are people who are above the rule, who are above the law. They showcase that every now and then. For example, in our country, what is in practice, or what I see that is in practice, is the rule of the leader, because everyone is not equal before the law. Some tribes are even more superior, and due process only favors some, and the likes of it. Again, they can even choose to put uh, due process aside to achieve whatever they want to achieve. Recently, there was a case of a judgment relating to a former governor and then senator, and how the whole system was maneuvered, to give a judgment that is suiting to a particular party. But all of that are issues that our current jurisprudence will deal with. But of course, the focus here is to see how the indigenous African society, you know, are, involved by the practice of constitutionalism. So, constitutionalism is based on the idea that government can or should be limited in its powers and that its authority depends on enforcing, this limitation. So basically, it makes everyone to work within the rule of law. And again, like we mentioned earlier on, before the advent of the colonial masters and all of that, the society, the indigenous African society, already developed a system that does not make their leaders to be absolute authorities unto themselves. Politics was the affair of the rulers and his appointed officers. Even when you look at the Yoruba system, the Obas, like the Emirs, the Ezes, Council of Elders, age grade, all of them play critical roles in the system. So the system was practiced in such a way that other aspects of the society could guide the leader, even guide the society. Although, as at that time, we would say that two major forms of political organization existed. That is the monarchical, which is the kingship, and the what we call the gerontocracy, leadership by the whole people or the elders, those elders in council, and so on and so forth. But when you look at under the monarchical system, that is a system where a king is elected from a royal family to head the to head the government. The king was assisted by an institutionalized council of chiefs. For example, in the case of the Oyo Kingdom, for example, there was check and balances. There was no absolute monarch or absolute Oba or president. When an autocratic king may be rejected, the direct demand may come in form of political rejection issued to the king. Again, we say that a ruling Alaafin could be rejected by his chiefs, that is the Oyomesis, for tyranny and wickedness. And how do they do that? They simply go through a laid down procedure that allowed them to present a calabash to the king. He should, go ahead and commit suicide. That's a way to show that indeed the system, of course, embraced constitutionalism. And what about the process of selecting their king? Due process were engaged. You see the consultation of the various age group, even the kings in council. Sometimes the shrines are consulted and all of that. As crude as those things may appear, all of that were the various systems that were in place in the indigenous African society that helped the society to run well. So, speaking generally of power in traditional African society, there were two sources of political power. First is the divine right, or which the society bestowed on the rulers, and again, the power that is in the people. The power that is in the people is what brings the elders and councils together, is what brings the age grades together to be able to say, oh, this is what the community wants, and this is what is to be done. So, in all of this, the traditional African society practiced constitutionalism, practiced due process, and separation of power at the same time. In some traditional system, the Obas does not have the complete say. When you look at the Igbo system that we looked at, the Acephalous system, there is no king that could unilaterally, force his decision on anybody. But the society has a way of running itself by the involvement of the various institutions, like the elders in council and the likes of them. So, speaking generally about the African society, the truth of the matter is that African jurisprudence is dynamic. And of course, like we said, focuses mainly on the concern of the society and how the society can generally develop, how the society can generally grow, and how everybody within the society can also benefit. But in all of that we have said about African jurisprudence, there is need for it to be enhanced because of modern reform that are taking place. Like I said earlier, when I was talking about caution about African jurisprudence, there are still some aspect of our system that still requires some form of amendments. Like I noted in this slide, I said the historical exclusion of women, even though it may not really be like a popular thing, but in some aspect or part of the African society, the women rights are still not fully enforced. Those are areas that we need to look at in the development of African jurisprudence. Like I wrote here, need for inclusive jurisprudence. South Africa, Kenya effort to align customary law with gender justice. Issues relating to women rights and all of that, still in one way or the other, still very much, a source of concern in the African jurisprudence, so to speak, and therefore there is need for us to improve on that. Also, there's also what we call the legal pluralism in modern Africa. That is the coexistence of statutory law, customary law, religious law, and sometimes when there are conflicts in between all of these, how is African as a nation or as a system, managing its own system of law to do this? And then there is modern relevance of African legal system. Of course, those are the things, the positive things that African jurisprudence has, brought to light. But in all of this, the wrong conception about African jurisprudence is what we have made attempt to correct, and to also speak of the various development that African jurisprudence has brought to modern society, in that most of what is referred to as modern system of law today were part of the things that form the foundation of the African society. So with this, we'll come to the end of the discussion on African jurisprudence, which has covered a long sum thinking about law in Africa, that is the concept of law and jurisprudence in Africa, and dealing with the various misconceptions about African system. And also we looked at the concept of like constitutionalism, due process, separation of power, checks and balances, and the way forward on African development. So all of these, form all that we have looked at in the course of this conversation. But the truth of the matter remains that there is no lecture that can provide all that you need to know, on these topics. This is just a lecture, and you still have a duty to research more, as I was even rushing to ensure that I finish the class before 9:30, and to also conclude the course so that you can, get set for your exams. So thank you very much for listening. And the recording of this class is available on YouTube, so you can take out time to listen to it in preparation for your exams. So I do not know if we have anyone who we want to take question, who we want to ask question, or make contribution to all that has been said in this class. Please, you can do
Good
that.
morning, sir.
Bring you to a close. Thank you very much. Yes, sir.
Good morning, sir.
Good morning, sir.
Well, as usual, let me thank you sincerely for this well-documented lecture. I think without praising you, it should have been delivered to people like Trevor Dopa and co, who said we had no past and history. or their disciples if they are still alive. But actually, I've taken us through very detailed excursion of the studies in African jurisprudence. Essentially and fundamentally, I think it's rooted in the concept of culture. And culture is the totality of a people's way of life, which includes the law, the social, the political, and other aspects of human life. So the peculiarities we may experience in Africa can be traced to our own culture as Africans. But modern times have come, so our past must address our present, and our present must address our future. Going back, I think the place of this particular topic should have come first before all these other ones that I'm sorry to say, I don't have a role to play in the design of the curriculum, but I think it should have come first before all these other ones we went through. That's my own position on this. But also, I recognize the fact that when people like Barrister Tunji Braithwaite, and when he did his thesis on the oracle of the jurisprudence of blessed memory, I can see why he chose to write on the oracle of the jurisprudence in his PhD thesis. Once again, I want to thank you, sir. It's not to praise you, but I also know, given your modern time religious inclination, how you were able to be talking about shrines and those kind of things, sir. But the truth is this: knowledge is knowledge. So we must document what is knowledge and what is true. And scholarship is about broad-mindedness. Thank you, sir.
All right. Thank you so much for your contribution. And we must continue to, to uphold the system, teach what we have to teach, and so that we can also have the required knowledge. Because of course, even though some of the things that we're talking about now are not things that are of now, history is very important, and then they also have a way of throwing themselves up in our contemporary time. But the good thing is that we need to continue to defend our own, especially when there are wrong perceptions about our system. And for me, the fact that the people comes first makes it all for me, rather than having a modern system that that the leaders or some people who are privileged can take advantage of against all others. All right, thank you very much for listening. We bring the class to a close, and I think that is the end of uh, the course jurisprudence for you. And I'm hoping that in the course of the exams, you will do well and you'll be successful in all of it. So I wish you all the best as you prepare for your exams. Thank you very much. The attendance for this class will not be counted because of the lecture-free week that we have. I only had to teach because the time allotted to me was already running into the lecture-free time. So please, I inform others who could not come not to panic, so that all of us will be good together. Thank you very much and enjoy the rest of your day. Bye.
Thank you, sir.